Hi, my name is Anis Mashita. So I would like to talk about legal issue. So based on the education provided, Mawar Sdn Bhd audited Cempaka Berhad's financial statement and they relied fully on the company's accountant and signed off the audit with company net asset 30 million ringgit. Dania, who was interested in investing in Cempaka Berhad, wanted to ask opinion from the company representative and they confirmed that the company's net asset is 30 million ringgit. Later, after Dania bought the shares, she found out that the company net asset were much lower and suffered loss. So the issue here is whether Dania, who invested in Cempaka Berhad after relying on the audited financial statements prepared by Mawar Sdn Berhad, can take legal action against the audit firm for losses suffered when the account were later found to be inaccurate.
Hi, my name is Wan Ain. So, this case is related to the duty to third party. Under common law, an auditor may owe a duty of care to persons other than the company itself, even in the absence of a contractual relationship. For instance, to investor or clients, an auditor may be liable to third parties for losses caused by a negligence audit if the following conditions are met. First, the loss or damage suffered by the plaintiff was reasonably foreseeable. Second, there was a relationship of proximity between the auditor and the plaintiff. Third, it is fair, just, and reasonable to impose such a duty of care. This principle was established in Caparo Industry Public Limited Company against Dickman because it deals with when a duty of care is owed to third party, people who are not directly involved in a contract.
Hi, my name is Shassmika and today I'll talk about the relevant case. The case is Kaparo Industry PLC vs. Dickman 1990. The fact is, Kaparo, a small investor, purchased shares in a company relying on the accounts prepared by the Dickman. Kaparo lost money due to the accounts being negligently prepared. The held is it was decided there was a proximity between the parties and that there was possibility of loss and damage. The Kaparo test forcibility, proximity, and fair, just and reasonable, and it was failed due to lack of proximity.
Hi, my name is Nur Alina Binti Azman. So the conclusion for this case is Dania is unlikely to win her legal action against Mawar Sendirian Berhad. Although the auditors may have been negligent in carrying out the audit, they did not owe a duty of care specifically to her as an individual investor. Their responsibility was only towards Cempaka Berhad and its shareholders as a whole, not to each investor personally. Therefore, based on the Caparo case, the court would probably decide that it would not be fair, just, or reasonable to hold the auditors legally responsible for Dania's losses.